And the Doomsday Couple on the docket tonight. Let me tell you, there was a hearing today out in Idaho. Huge, monumental development, okay? Big, but I'm not going to tell you what it is. You've got to figure it out for yourself. I'm going to show you 3 minutes of the hearing, okay? 3 minutes. Watch these 3 minutes and listen very closely, because they kind of sneak in a little thing here that isn't so little. To me, it speaks volumes. Take a listen.
We have a trial in the case that's scheduled for November 8th, so 2 months from today. In the intervening time period, we've got some motions that would be heard. We've got a change of venue motion scheduled October 5th and 6th. There's also just been filed a motion for severance. And further, the grand jury transcripts are, as I understand it, almost completed but not yet completed and submitted to council, which are necessary for review by the defense as well as the state in order to go forward. Those are not done. And so given all those circumstances, council, I know we've discussed this previously informally, but it would appear to me, one other important point I guess I'll bring up, there was a waiver of speedy trial filed by Mr. Daybell on August 20th. And so given all those considerations, it would appear to me that really it would be impractical to try to commence this case 2 months from today on November 8th. I understand there may also be some discovery issues that are not yet completed. So the court really on its own motion feels like it's probably appropriate to continue this trial. And so that's where I think we're headed. But before I go ahead and make that final decision, I'll just ask first from the state, is there any objection to us vacating and rescheduling the trial in this case to allow for additional motion hearing?
There is not an objection, Your Honor.
All right, Mr. Pryor, have you spoken to your client about the possible continuance of the trial in this case?
Judge, I've discussed with him and done my due diligence. There's no objection.
Okay, without any objection, then that's just the reality of where we are in this process. I know there's a large amount of discovery and other probably significant motions that need to be heard. So the court is going to vacate the trial currently scheduled for November 8th. What I'd like to do is get one more trial date scheduled that would be the date that will stick. In order to get a date that we know is going to work and we can stick with, I think it's going to be necessary for us to set a scheduling conference after the change of venue motion, because depending on if venue is changed or not, that could have an effect on our scheduling. So I will reach out to council and we'll set up a scheduling conference sometime after the October 5th and 6th change of venue hearing, and we'll get the matter reset for trial after that motion's been determined. So that'll be the ruling on the current trial setting. Any questions on that, Mr. Pryor?
No questions, Your Honor.
Any questions from the state on that regarding the trial setting?
No, Your Honor.
No, Your Honor.
Okay, so were you listening? So do you think it was the change of venue, that they're going to try this case somewhere else that's so huge? If you said that, you were wrong. A new trial date, November 8th, no longer the trial date. They vacated it, and this is going to be tried sometime next year. Is that the big development? No. The severance motion by Chad Daybell doesn't want to sit in court next to Lori anymore. What does this mean? Let's bring back in the think tank. Kirk Nurmi, what does this mean? Chad Daybell wants his own little trial, actually big trial, but does not want Lori Daybell, his wife, his soulmate, you know, the second segment of his life, you know, the one who's going to lead the 144,000 with, doesn't want her sitting next to him in the courtroom. Why not? What does this mean?
Well, there could be lots of reasons. Unfortunately, Vinny, their motion only contained about 2 pages and didn't have any reasons. But I think they're obviously concerned about the evidence that Lori is going to present, what Chad has done that might not relate to the killing of the children, that is going to infect the trial, that's going to paint him in a demonic light, if you will. He's painting himself as a holy man, but his actions might be all demonic. And her change, her subservience to him, her adherence to him might be exactly what he is concerned about in terms of his trial.
Nima, should the prosecution be concerned here that you're not going to have, that potentially you don't have Mr. and Mrs. Daybell together at trial?
Vinny, if you're the prosecutor, you absolutely want Chad and Lori together. Try them both, convict them both, but it's not going to happen here. We know that the defense is going to file a motion, severance motion in this case, because really the only defense is to blame one another. We saw it in another trial that started today in Elizabeth Holmes and Theranos. It wasn't me. Lori's going to blame Chad. Chad's going to blame Lori. That's how this is going to go down. So I fully expect the judge to grant this motion, the trials to be severed, especially now that Lori's is going to be delayed because of the temporary incompetence.
Eklund Mercy, I mean, is someone going to be served with divorce papers now after this?
Oh, God. First of all, the marital privilege went out the window when you are charged with felonies. So, with that being said, it's carte blanche for the wife, and it's going to look bad for Mr. Daybell. So I am concerned, like, it's going to be good television either way, but we're going to hear a lot about their relationship. What you usually do with cases like this, I go hard on the co-defendant. So there is going to be no breaks, just gas. This trial is going to be the trial of the year.
Okay, let me ask you, Kirk, and Kirk and Nima brought this up, pointing the finger. So if Chad's pointing the finger at Lori, he can also point it at her dead brother, Alex Cox, the one who died on the toilet in Arizona, where you live. Not the same house, right? Not the same house, but same state.
Not the same house.
No, same
True.
state, though. So do you think a jury could be persuaded that it was Alex and his kooky sister who murdered the children and buried them in Chad's backyard?
It's possible. Vinny, with this case, I always hate to say anything with definite certainty because there's so much this onion keeps peeling and it keeps getting rotten and rottener every time we peel something off, right? So I think ultimately, yes, they could. And this is what Nima was talking about, these antagonistic defenses, that they're going to wait on, throw the responsibility on the other person and maybe even the guy who's not still alive. So, Eklund's right. This is going to be the trial of the year. And having it separated, I would disagree with Nima a little bit because having it separated, while it's going to be a more enduring and more tough road to hoe, a longer road to hoe, I think it'll make it a little cleaner prosecution for both cases because with both of them sitting there, it could get real messy and real ugly, and the jury could easily get confused.
Okay, all right, we don't have a trial date, but we do have the next hearing date in the case now, okay? We had a trial date, that's gone. Change of venue for Chad, October 5th and 6th. This is significant because I personally think it may get moved. It may get moved because it's such a small community, but we'll see what the evidence is and how the judge rules. And then, as the judge said, after you have that change of venue, then we'll get what we call in the business a firm trial date, which I believe will be the real trial date.